Hello, everybody. Welcome to Know Your Money. I'm Bronwyn Weiner.
And I'm Craig Finch, and we are from Growth Financial Planning. We hope you enjoy our podcast. Hi, everybody. We've got Charl Du Plessis, who's an independent attorney specializing in trusts and wills and estates. Charl, good to see you again. And can you introduce yourself to our clients and our guests?
Thank you very much, Craig.
Viewers.
Thanks for the opportunity. Thanks, Bronwyn. Yes, I am a practicing attorney in Johannesburg. I'm a notary public. I have my own firm, Charl Du Plessis Attorneys, and we do a lot of transactional work, and part of the transactional work are also estates, wills, and trusts. What we have found, Craig, is that for your clients, for example, when somebody had to passes away, how long it takes for a estate to be wound up. There are many hurdles, and one of the biggest hurdles is a will that is not validly executed. It can cause tremendous prejudice and suffering for your clients who passed away, their family, for their descendants and family members. What I'd like to do is discuss with you just a couple of aspects that will prevent a scenario happen where there's unnecessary delays and your family are prejudiced thereby, or the testator's family is prejudiced thereby. So let's just start basically with a will, if I may.
Yes,
and
please.
just say that a will is a very powerful document. And that's basically because the testator is no longer there to be questioned what did you in fact mean. So make sure that your will is unambiguous, clearly drafted, and that it cannot be challenged. Now, wills get challenged for various reasons. By aggrieved family members, previous spouse, divorces, and it happens. So in order to avoid a scenario like that, let's just look at some of the formalities. And one thing I just want to add is that people may say, yes, but I can always get relief from court. I can go to court. Be careful about running to court. You want to avoid that at all costs. Just to give you a quick example, an advocate today would cost you 40,000 Rand, and that's just to be one day in court. He'll prepare 3 days. They normally say the general rule is 3 days. That's 120,000, 140,000 Rand, plus the attorney, and you go to court. So it is an unnecessary expense just to go to court. And then often it goes to the Supreme Court, take years. So there's a big cost involved, and avoid that. So let's just get to the formalities of a will. It's governed by Section 2 of the Wills Act. The Wills Act comes from 1953, but it's been amended regularly on a regular basis. So the first thing, a will must be written and must be signed by the testator at the end of it.
So written, no verbal. What happens if the person can't write?
If that person can't write, then he can dictate it to somebody, tell somebody who it is, and the will does provide for somebody to be to write the will and sign the will in his presence and by his direction.
Okay, so these.
But if that happens, then there must be a commissioner of oaths that certifies at the back of the will that he has identified and satisfied himself as to the identity of the testator, and that this is in fact the will of that testator.
Okay.
And just in terms, testator is the person
The testator is the
writing.
person who.
Yes.
No, the testator is the deceased.
Yes.
So you can
Person
write it on
whose will
behalf
it
of
is.
somebody. Yes. So now be careful because the courts take a very strict approach. So they have. And for example, a commissioner of oaths, he had certified in his capacity as he was the family attorney, and came out certified, and he signs it as an attorney. The court held that will is not valid because he didn't certify as commissioner of oaths.
Oh, my word.
And when you sign, it says sign at the end hereof. And there's been a case where there's a 2-page will where there was a 9-centimeter gap and a 13-centimeter gap when the will ended, where the last word of the will was where he signed. That will was held to be invalid because it wasn't at the end.
So at the end, it means every
Yes.
page.
No, at the end, you must sign it at the end.
Okay, not every page.
The testator signs every page.
Every page. Okay.
A witness doesn't have to sign every page. He
Right.
signs at the end.
Okay.
But a commissioner of oaths, in our example, he has to sign every page as well.
Right.
So be careful, therefore, don't leave gaps at the end. and signed as don't leave a 13 centimeter gap. And then also the witness. The will says it must be in the presence of two people there. So don't be, for example, say, oh, I'm nervous as a witness, I'm quickly going to have to wash my hands, and just pop up to the bathroom and wash your hands because you've got sticky hands or something like that. It has been challenged that the witness is not present.
Both witnesses present.
Both witnesses were
So
present.
you can't say on Sunny will sign today and then take it to the neighbour and then take it to the other neighbour.
You can do that. That has happened.
Okay.
The Wills Act does allow for that, where the testator has signed. He then got in his car and he drove to his business colleagues. But there he told them, both of them present, this is my signature. I've verified as my signature. Please sign in my presence. That the Wills Act does allow for.
So you can't sign it and then drive down the road and get your neighbour and then drive to another neighbour.
You could if you, at each, no, the two witnesses must be
They
present.
must be present.
Two
Okay.
witnesses must be together when
at
they
the
are
same
signing
time,
as
yes.
witnesses.
Okay.
That's signed.
And the witness can't be someone named in the will, correct?
Yeah, you cannot, a witness, let's be very careful of those as well. A witness mustn't be saying somebody that takes a benefit under the will.
Okay.
For example, I draft the will for my dad and my wife wanted to be the witness because I took benefit on it. You can't have that. So you must be an independent related party. Having said that, the courts have had a very strict approach in the past. In 1992, they brought in, and it led to a lot of hardships. For example, why would my will be invalid just because there was a 13 centimeter gap?
Yeah.
Or it's obvious that the attorney is a commissioner of oaths by his office.
Yeah.
Now, the whole will is invalid because of that. So, in 1992, there was an amendment act that came in. And under that, it does give the court a leeway to interpret the will according to the intention of the testator. And the court will look at the intention of the testator and make sure that does this will reflect his intention and interpret it like that. But again, you have to go to court.
Okay.
And we got those costs. And the more your will...
Delay as well.
Delay. The more your costs, your will deviates from Section 2 of the Wills Act regarding the formalities, the more difficult it's going to be for a court to be satisfied.
What happens, Charl, if you can't find the original will?
That is well, if you can't find it...
There's a photocopy, you've got a copy on file, but you haven't got the original.
Yeah. The photocopies are not generally accepted as originals, but you can bring... the will does provide that is the best evidence that you've got.
So master could accept it.
I could accept
But
it.
there's a cost.
But there's a cost. Yeah, you have to go to cost and get a court advice, again, go through a process of the court being satisfied as to
So the master might say, I don't accept this, you've got to go to court and prove it, and then you got to go to court, and then all those costs. Okay.
So the court application, so just avoid these sort of things as much as possible.
Yeah.
So get your life sorted before that. For example, I'm guilty of that as well. My father said he died of cancer, and those who've had a parent, you'll know that the last few months are hard, difficult. He was in the bed. You don't want to go, as we had to go, when he's in the ICU, suffering from cancer, to get him to sign a will. There can be challenges to that. Now, one aspect that I would also like to bring to your attention is that there's a concept in our law, and people are very funny. We see very funny cases. There is a concept in our law that says, der bloedige hand neemt geen erf, which is a Roman Dutch principle, says that if you wrongfully cause the death of somebody, you cannot inherit under that will. And that is to prevent bad faith and people...
So somebody murders their wife.
If somebody murders the wife, the leading case is one of the cases, a very funny case, well, not funny, it's actually tragic, was the case of the De Wetts. They had a terrible marriage. Mrs. De Wett organized for her, she and her lover, to assault her husband so grievously and she said in court with the intention that he is confined to a wheelchair. She opened the door, the lover came in and assaulted her husband, but he shot him 18 times, and he went overboard,
That's
And
like
her
it.
defense was that
Just
it was
a bit.
never, and in order to be
He didn't
found
listen to
guilty,
the brief, did he?
in order to be found guilty of murder, you must have intent. And she said it was in court. It was never my intent to murder him. It's only my intent to put him in a wheelchair. So I should be able to benefit.
Did he die?
He died. So she said I was never to be guilty of murder. You must have intent. And she said it was never my intent to murder him. It's only to put him in a wheelchair. So I must be able to
The lover
benefit.
definitely didn't get the brief because
Yeah.
18 shots is.
So I must therefore be entitled to benefit on their insurance policies and in their estate. And the judge looked at it, and through public policy considerations, he did not allow her to benefit under the will.
Okay.
But to take that one step further, and again, it goes to show how it happens to practical families,
Yeah.
is that that concept is extended to negligence.
Okay.
So if you were negligently caused somebody's death, you also cannot, there's a possibility you cannot inherit. So be careful of that, but you can provide for a clause specifically in your will that a person that causes your death negligently can still inherit, but it must be in your will. So for example, with my wife, her mum was quite ill, she passed away in November, and she would have Mom's Monday. And Monday she'll take her to the doctor, go shop and all those sort of things. What happened when my wife went through a red robot and her mother was killed? And it's found that she was negligent. She was scratching around in a bag to get a phone, or she did whatever. And there's somebody else who's lodged, the other party lodged a claim, and they're found to be negligent. And then there's a sibling that comes and says, Charles' wife caused this accident, her negligence.
Yeah.
The bloedige hand neem geen erf. She mustn't inherit because then I'll get more.
Okay. Yeah.
So in your will, there's a clause you can insert that provides for that. Okay. Another aspect is also that if you're suffering, not suffering, but your family haven't got any, if the main breadwinner dies, that you can provide in your will that maintenance is paid between the period that from the death until your estate is wound up. So you can direct the executive to pay a monthly maintenance to your wife or her maintenance and support of, say, whatever the amount is that you require.
Yeah.
Insert that in your will. So in this 2-year period when it takes for estates to be wound up, that at least your family have got money and they can carry on their normal lives, not have to wait for this estate to be wound up.
Awesome stuff.
Great, Charles. That's
Thank you so
good
much.
insight on that, because you generally think, quickly sign the will and it's an easy document, but it's actually more severe. Not severe, but it's a really important document. We believe that in our practice, it's such an important document. But I think when you sign it, you must realize how important it is and what you're trying to achieve.
No, it's a very important document. Regrettably, people don't attach enough value to it. I'm not going to go into we can do in a later session, perhaps, on creating trust, estate planning, all that sort of stuff. But you make sure, hurdle number 1, get a valid will properly executed by a specialist.
Brilliant. Thank you, Charles.
Awesome.
Brilliant.
Thank you so much.
Thank you.
Thank you.
That was great. Thank you for listening. If you have enjoyed this podcast, would like to subscribe, please visit our website, www.growthfp.co.za. The information we have provided in this podcast is our personal opinion. For more detailed information, please discuss your financial situation with a financial planner.